They'll figure it out. That's the only area that is free, that's what
All rise. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Please be seated.
What's your first step?
There we go.
Yeah, okay. Here we go.
Okay. Lots we have to get through at the beginning of the day. But we so far are getting through them. We appreciate your attendance at the February 6th. Is there an echo? Or is it just me? I'd say blame it on my hearing aid if I had a hearing aid, but it seems echoey. Thank you for your appearance at the February 5th, 2025 setting the 7th Court of Appeals. We have 3 cases this morning. We had one this afternoon, but that went away temporarily, so that's not your problem. We'll go on and call the docket. All of you here have argued before here, so we will not, I see no need to give the general admonitions I generally give. So we'll just head on into calling the docket. First case we have is 07-24-00056-CV, Wolfcreek Minerals LLC and Brett Duke versus Warren Power and Machinery LP, DBA Warren Cat and IROCK Crushers LLC. And for the appellants.
Brantley Jones, the appellants.
Very good. And for the appellees.
Your Honor, Elizabeth Geary for IROCK Crushers LLC.
Okay.
Morning, Mary Kathleen Davidson for appellee and cross appellant Warren Power and Machinery LP DBA Warren Cat.
That is a mouthful. You did good. Question. That's gonna bug me. With regard to the appellees, are you splitting your time? And do you agree to do that?
That is the plan. Depending on the court's questions, there are some questions that don't apply to IROCK, and so I can defer some of my time to Ms. Davidson if we have that flexibility.
Your Honor, I intend on covering the attorney's fee issue, the lack of standing, the proportionate responsibility issue, and depending on the time the court's questions, the large transaction exemption waiver error as it applies specifically to Warren Cat.
So a lot of topics to cover and whatever time is co-counsel. I may leave you, so I will let you. I understand there was no request for additional time.
That's correct.
So we're still working under the 20 minutes. And you're going first.
Yes, Your Honor.
Okay. And I still remember you as Elizabeth Clark, so excuse me.
That's okay.
It sticks in an old man's mind.
Sure.
Ms. Geary. But you'll be regulating your time. We will not be regulating it. So if she is going over your time, you think you need something to address, you got to give her the Scott eye or something like that and catch her attention. Okay. We will not do it for you. Okay.
Okay, there's about 10 minutes left.
Okay.
At the very least.
Okay. Thank you.
Thank you.
With that said, Mr. Jones.
Good morning, and may it please the court.
Counsel.
My name is Brantley Jones, and I represent Wolfcreek Minerals LLC and Brett Duke at the appellate court and back at the trial court. I'm here today not only to correct or to ask you to correct legal error that has harmed my client, but also to vindicate the decision of a jury that spent 5 days of the bad luck of having the Jones boys in stereo, who arrived at the wise verdict that appellees committed violations of the DTPA, committed fraud, and committed negligent misrepresentations. The trial court disregarded that jury finding and entered a judgment against Brett Duke, basically for attorney's fees is what the positive amount came out to. There are 4 prime errors that need to be addressed, and each of which requires a reversal and a remand for new trial. The first has to be taken first is the judgment non obstante veredicto that the court rendered on defendant's large transaction exemption defense. The next would be the court's decision in awarding attorney's fees to Warren Catt without a hearing and in an amount that is just patently excessive and without support from a document, a contract, or a statute, and proportionate responsibility questions without providing a predicate question of liability to determine if Wolfcreek had in fact engaged in culpable conduct, which to apportion liability from. And finally, in directing verdict against Brett Duke, finding that he didn't have standing individually to bring a DTPA or fraud claim.
You also brought, in addition to DTPA, you brought claims under fraud and misrepresentation, is that negligent misrepresentation, is that correct?
That's correct.
Okay, and the jury's verdict on those was what?
The jury determined that IROCK had committed fraud and that Warren Catt had committed negligent misrepresentations. Unfortunately, and this is apparent from reading the jury charge, there were some problems with the charge, and we neglected to put in a question regarding damages on fraud. So the fraud finding stood by itself effectively. That will not happen should the case be remanded for a new trial. The large transaction exemption was the basis for the court's judgment, notwithstanding the verdict. The large transaction exemption exists in Business and Commerce Code section 17.49G. It provides that nothing in the subchapter shall apply to a cause of action arising from a transaction, project, or set of transactions relating to the same project involving total consideration by the consumer of more than $500,000, other than a cause of action involving a consumer's residence.
Did you say set of transactions?
That's correct.
When the business relationship began, was it based just on a lease, or did that lease have an option to buy?
The RPO agreement is a rental with purchase option agreement. And so there was at the time of the contract, Brett Duke was locked into either paying a minimum of 3 months of rental fees or a maximum of 12 months of rental fees, but he did not have to exercise the option to purchase.
But he had a right to purchase,
He did have the right to purchase at any point during that 12-month period.
and that would right have been enforceable
It would have,
against your opponents.
yeah, he would have been able to evoke that right within the 12-month period, according
The reason why that right to purchase should not be factored into the total price in determining the value of the transaction, so to speak.
Well, the hypothetical option to purchase hanging out there by itself would technically be consideration by Warren Catt in Brett Duke's favor. Brett Duke would then have provided his own consideration for the option price in the fact that the ultimate purchase price would be reduced by rental payments made throughout the term period, but at a declining scale based on how many months the
ultimate purchase price was over $600,000.
The ultimate purchase price, I believe, yeah, total $600,000 if you put the rental
And
agreements.
then you deduct the rental.
Right.
You do acknowledge that it does arise out of the same project.
The project being the lease of the rock crusher. Yes, I mean, the two agreements are the singular agreement with two components. At the beginning of the transaction did not obligate anyone, or did not obligate Duke or Wolfcreek to purchase the machine. And in fact, they likely would never have even considered it, but for exigent circumstances that were discussed thoroughly at trial, including the fact that they were able to get the machine to work vaguely through the efforts of another party who was kind of interested in perhaps purchasing the machine at a future date. None of those facts are operable on this appeal.
Does it matter whether there was an intended purchase at the beginning or not? I mean, I think the record shows that the fair market value of the equipment was certainly greater than $500,000. Whether the lease payments total $500,000 or more, there was certainly an agreement for your client that would tie up the use of that equipment during a period of time during the lease.
And that's true, and that's the lease term approach. He was receiving calls from Warren Cat requesting that he either start moving towards conversion or return the equipment because they had other people interested in it.
I'm just
Now-
wondering if there's any authority on that that says, I've got $1 million piece of property. I'm gonna let you lease for $1 a year. How that value is figured? Is it only based on the consideration that's paid, or do you look at the total transaction?
And that is the question ultimately that's at the heart of this issue. Do you measure the consideration by what was actually paid, what was promised to be paid, what amount is in dispute? The authorities all eventually support a notion that you look at the ex ante basis, the period of time when the contract was entered into. Consideration being the inducement for a contract. This follows that you would look at what the parties agreed to when they entered into the contract. That allows
we
you
have 2 transactions here or just one?
just one. The appellees are going to argue that the Brett Duke's signature on a lease rental purchase documents called a conversion sheet through the briefing indicates an intent to execute or to activate the purchase option. The evidence on that is conflicting. And if you look at the timeline of events, he signed that agreement. The agreement states that it's like 10/23/2018. We know based on text messages between Warren Cat and Brett Duke that they hadn't received a signed copy of that agreement as late as November. On November 2, there's a sales link document, which I believe exists in the record at Plaintiff's Exhibit 44, 8RR or 8 Reporters Record. Exhibit 44 shows that on November 2nd, they indicated that the conversion of the equipment was ongoing. They're still working toward getting it converted. The entry was made on 11/6, and so the facts reflected from 11/2 we're still operating on 11/6.
Does the conversion sheet incorporate by reference the terms of the RPO?
Yes. But importantly, on 11/8, we returned the equipment to Warren Cat. Warren Cat accepted the return of the equipment, did not charge or seek specific performance of the conversion agreement. Effectively, if there was an exercise of the option to purchase, it was bilaterally repudiated. And so this court will have to determine whether or not a contract that remains executory and is bilaterally repudiated is sufficient to activate the large transaction exemption. When at the beginning of the contract, neither party or there was no consideration that would have activated the $500,000 exemption. And you look at the beginning of the contract for very good policy reasons. If you look at the Spacemaker case, which I believe was cited by all the parties.
But at the beginning of the contract, you had this umbrella document talking about the lease and the option to purchase. Right?
That's correct.
And that both of them were enforceable at the beginning of the contract.
Sure, yes.
So why not? For your analysis, your date, right? You say ex ante? Is that what you said in your
Right. That's the language used by the Spacemaker court.
Okay. The ex ante, if you look at the beginning of the contract, the beginning of the contract still had an obligation to lease, an obligation to sell if they exercise the right. It's a valuable right. And the cost, could they have exercised the right at day one? Just say, forget the lease, I just want to buy it.
That's an interesting question. And I thought of that right as you started this line of questioning. I'm not certain there's a clause preventing it, but the lease term is a minimum of 3 months. I would assume they had to have it rented for at least 3 months.
Okay, after 3 months, they could have exercised it.
Though I do believe the purchase option itself says that it can be exercised at any point during the term. So now,
So why not value it at the beginning per your analysis?
Well, because neither party knew what the value was at the beginning. If you look at the
They
RPO agreement,
knew that this involves a piece of equipment over $600,000.
well, we know that the equipment cost Warren Cat some $600,000, but the DTPA exemption isn't activated by the consideration Warren Cat paid. It's activated by the consideration by the consumer. And so the option hanging out there, perhaps exercise, perhaps not, is not consideration by the consumer until it's
It's the consider.
actually activated by the consumer.
What
Now,
does the statute say? The consideration paid by the consumer, or does it just say the value of the
it
transaction, a series of transactions, set of transactions?
17.49G says it's consideration by the consumer. It doesn't use the word paid, but
Yeah,
it does
this
say,
is involving total consideration by the consumer. It doesn't say.
right. And at paragraph 20 of the RPO agreement, as
So
well
you're
as on,
saying the consumer didn't provide any consideration?
well, the consumer's consideration at the beginning of the contract would be, I will pay you $26,900 as a lease term each month for a minimum of 3 months and a maximum of 12 months. That's what
Who could exercise?
he
the
was
option to buy?
obligated to do on the first day of the contract.
Who could exercise the option to buy?
He could exercise the option to buy.
The consumer?
Yes, and Warren Cat, I
So
don't think.
They have a valuable right.
The consumer has
consideration
valuable
too, and there would be an obligation on the opposing party to sell it.
Right, but there's not a fixed value on day one for the option. Now, the document itself shows some $644,000. But the paragraph just following that, which is tiny, so I'll refer to paragraph 20 where the language is repeated. It says that the lessee and lessor can consider the credit payment of adjusted option price. The credit terms can be agreed upon by the parties. And so there's this process or an assumption of a back and forth at the option and purchase stage where the parties agree on what the ultimate price will be. Moreover, the lessor retains discretion under the contract. It says the option price may be adjusted upward or downward at lessor's discretion based on the following factors: billed rentals, unpaid rentals, and then the last part of that sentence says other factors determined by the lessor. So the lessor retains almost unlimited discretion to change the purchase price. Hypothetically, they could say that the purchase price was $1. And if they did that, the DTPA clearly would not apply, despite the fact that it said $644,000 on the front page of the document for the option price. Now, assuming that the DTPA applies at a time other than the ex ante period, the evidence at trial was inconclusive as to what effect the conversion sheet had. Brett Duke's signature appearing on the conversion sheet by itself should not constitute evident or definitive evidence sufficient to support a JNOV that the option to purchase had actually been exercised. If you look at the 8 reporters record, exhibit 17, defendants 17, it's plaintiffs 44, that sales link document I discussed earlier clearly shows that the process of purchasing was an ongoing discussion as late as a few days before the equipment was turned into Warren Cat, and Brett Duke was impatient.
What did the terms of the conversion sheet say his signature was? Did it say, I accept the terms, I agree to negotiate? Or is it just a signature by itself, or what's the record gonna say there?
It provided that it was that the customer is going to purchase the equipment at the price stated on that document. Brett Duke testified at the reporter's records, like 3 reporters record 262 to 265, explained that when they approached him with that conversion sheet, thought it was part of the process of arriving at a mutually agreed upon purchase price, like you would with a car dealer, so that people can't take the car off the lot while you're in the process.
We've got another case later today where we've got to interpret what contracts mean and when they're ambiguous and when they're unambiguous. Is it your position that that document combined with the the other document was not a complete contract. I mean, it seems like it's got a price, it's got a quantity, it's got other terms. If, for example, Warren Cat didn't decide you can't have the machine after all, I mean, it seems like there's an enforceable contract at that point, even though they don't have the other details worked out.
Right, they didn't have the details worked out. There were important obligations on both sides.
But what about
that
the
had remained
material,
unfulfilled.
the material terms of the contract? Were there, the material terms would have been covered under the two documents looking at them together?
Yeah, the terms and everything are complete. We're not arguing that the contract failed as a contract. We're arguing that the period of time where this purchase option was arguably being exercised, that the purchase option remained executory and was ultimately bilaterally repudiated, and therefore cannot constitute consideration by the consumer. I see that I have fewer than 5 minutes remaining, and though I didn't touch any of the other 4 very important issues, I commend those to the briefing.
You can give it to Ms. Davidson. She may
Well,
want to argue.
reserve my 3 minutes and 13 seconds for rebuttal. Thank you.
You have 5 minutes for rebuttal.
Oh,
Yeah.
so I get the full, oh,
You have
I'm sorry,
8
I
total.
was mixed up there.
No, that's fine.
All right, do y'all have any more questions on the 17.49G exception?
No.
Because if not, I'd like to move on to the attorney's fees award as probably the second most harmful part of the judgment to my client.
So the law in effect at that time said that you can recover against LLCs.
That's correct. Yeah, so at the time the parties entered into this contract, there was that, I guess, now well-known hiccup that 38.001 did not apply to limited liability corporations. Here, the RPO agreement provided that in any event of default by the lessee, the lessor shall have all of the rights and remedies provided by applicable law, including recovery of attorney's fees and other costs for enforcing the RPO. So that language clearly references applicable law as the basis from which attorney's fees can be recovered. At that time, or as always, the applicable law in Texas is the American rule. The parties bear their own costs unless provided by a statute or a contract. So here, the contract says attorney's fees, but it pegs that to applicable law. It can either, if the contract itself supports an award of attorney's fees, then all sorts of problems arise. One, just pure circularity. Applicable law says you can have a contract that provides attorney's fees. The contract points to applicable law. Therefore, it's a mess. But more importantly, it reads out the word including and has other implications, like there's no standard governing when attorney's fees would be available to Warren Cat. Is it in any event of default, is a suit even required? Do they have to prevail? None of that is covered. The better reading, the reading that's consistent with the plain wording of the contract is that if applicable law allows for attorney's fees recovery, then you can have the recovery of attorney's fees. Under that situation, 38.001 of the Civil Practice and Remedies Code is the only basis for recovering attorney's fees against Wolfcreek on this contract. And so, since 38.001 doesn't apply to LLCs, there's no basis for awarding an attorney's fee award against Wolfcreek.
What did they plead a particular statutory provision?
Yes, they actually did cite to 38.001 in their original petition as a basis for fees. And I believe the motion for attorney's fees also relied on 38.001 as well as the contract itself. In any event, appellants weren't given an opportunity to question the fee award because the motion for attorney's fees was granted without a hearing being set 4 days after the motion had been filed. So we argued for the first time that the fees were excessive. And I see I'm out of time.
I want to finish your.
Yeah, we weren't provided an opportunity to argue that the attorney's fees were accepted until our motion for new trial.
Time goes by fast up here, doesn't it?
Certainly does.
Mr. Chief Justice, and may it please the court. Your honors, this is a case where the trial judge fixed any issues as to IROCK with the jury charge in the judgment. This court should affirm for 3 reasons. First, whether it is a transaction or a set of transactions, the total consideration exceeded $500,000. Second, IROCK preserved its defense and objections concerning the large transaction exemption every step of the way. And third, Wolfcreek did not preserve its objection to the proportionate responsibility question because it vaguely objected and did not submit the language that it complained was missing. Now, your honors, earlier Justice Doss asked what was the language that Mr. Duke agreed to in the conversion invoice. Specifically, Mr. Duke hereby agreed to purchase this machine described above and the stated conversion price in accordance with the terms and conditions of the original agreement. It is not ambiguous. There was no disputed testimony that brought this written agreement into question, and the trial court got that right.
What about the other evidence that there were still transactions that were needing to take place in the end of October, first part of November, that those hadn't occurred?
As far as the unpaid fees,
I'm not sure. Mr. Jones made reference to that a while ago said, well, it was executory because there were other matters that still needed to be worked out, notwithstanding his client's signature on the document.
well, as far as the large,
the value of something too.
Right.
as far as the large transaction exemption goes, Justice Parker pointed out that the statute actually states what is the total consideration involved by the consumer. It does not require that the total consideration be what has been obligated or what has been guaranteed. There are many cases in which the total consideration may be changed later. And here it's disingenuous to say that it can be changed later by repudiation, because that's exactly what these courts are attempting to avoid with the ex post look at the total consideration. But at the time that the conversion invoice was executed, we contend that there were all of the agreements that were in place were due and owing, and that at the time it was repudiated, there were still amounts owed to Warren Cat by Wolfcreek. And so we don't contend that there was anything still lingering out there at that time. And it's unclear exactly what that was referring to. But here we know that
Who was the consumer?
I'm sorry.
Who was the consumer?
Well, Wolfcreek contended that it was the consumer, but the legislature has spoken to that and noted that the purpose of the DTPA is to serve individual consumers, not to serve large businesses that are engaging in large transactions such as this. We know that Wolfcreek used this crusher in a project in which they billed their customer $1.3 million. And so the idea that Wolfcreek is a consumer under the DTPA is entirely negated by the facts in addition to the written agreements.
Statute, the exemption refers to consideration related to the consumer, correct?
Correct, Your Honor.
So who is the consumer for that statute in your view?
In evaluating a statute as applies to this case, this court should look at Wolfcreek as the consumer. However, that does
Your
not.
view is not, it's not for purposes of the exemptions consumer, but for purposes of liability, it doesn't apply to Wolfcreek in your view.
As far as the amount that is owed at this time or was agreed to be owed by Wolfcreek?
No, just liability in general under DPTA.
Well, Wolfcreek is the only party that brought a claim under the DTPA. And so that is why we're looking at whether or not Wolfcreek qualifies as a consumer. But the exemptions.
Opposing counsel to me is indicating, and maybe I'm misinterpreting his argument, but I hear him as suggesting Wolfcreek is not a consumer.
Well, if that's the case, the DTPA.
Am I interpreting that?
Well,
And if I am, you can correct me, okay?
Well, if that's the case, then the DTBA certainly does not apply to Wolf Creek, because Wolf Creek must first be a consumer, but then also get past all of these exemptions as well. And the large transaction exemption reflects the legislature's intent that this statute and the set of remedies that are involved protects the individual consumer primarily.
I thought Mr. Duke also made the argument that he was a consumer. Did I misunderstand that?
Mr. Duke did make that argument. The court found as a matter of law that Mr. Duke was not a consumer. And the reason for that is that all of the facts show that Wolf Creek is the lessee and the purchaser of the equipment. The fact that the conversion invoice named Mr. Duke is clarified by the original agreement and by all of the facts. There are no facts that show that he was a third party.
Was he a guarantor?
No, Your Honor, I do not believe so, but I will let Warren Katz speak to that
I
specifically.
thought he was a guarantor.
Let's assume he was a guarantor, but with regard to the original agreement, did Duke sign it on behalf of Wolf Creek?
Yes, on the original agreement.
When he signed it, is there any indication that he signed it in his individual capacity or his capacity as the chief official of Wolf Creek? I don't know if it was president or what. I mean, it was apparently his company.
And I believe the original agreement was clear that he was signing on behalf of Wolf Creek.
So it probably had something under there, Duke, president or something like that.
Correct, Your Honor. It was the conversion invoice that only identified Duke. However, the facts clarified the disparagement between the two agreements to show that Duke was never using this piece of equipment in his personal capacity, that it was always used for Wolf Creek in their capacity. And this is consistent with all of the cases, even Spacemaker, that have reached this issue, because in looking at the agreement from the beginning, we can see that the large transaction exemption applies, and it does not somehow bifurcate the two that he signed as Mr. Duke on the invoice. And Wolf Creek seems to be trying to bifurcate it and make it two separate agreements, but earlier council specifically stated that it was an agreement with two components, and we agree. This is an agreement that allowed a second component to be exercised at any time. And so while it may be a closer call as
The component being the purchase of the equipment
yes, Your Honor,
and the
that's
first
correct.
being the lease.
That's correct, Your Honor. Yes. And so it may be a closer call if Wolf Creek had never executed the conversion invoice, but that's not the case here. And this court never has to determine that question. This is at the very least a set of transactions that applies here. And that's specifically the language that the legislature chose. And it's the same two parties. It's the very same piece of equipment. All of the complaints from Wolf Creek are about this same piece of equipment that apply to both of the two components of the agreement. And therefore it has to be combined to be the large transaction exemption. Your Honor,
Were you covered by the negligent misrepresentation finding, or did that only apply to Warren Cat? Did that apply to you as well?
the jury did not find that IROCK had committed negligent misrepresentation.
Okay, I know you were arguing something about that you didn't believe it was preserved, that the proportional responsibility portion was being reserved. Is that something you need to address, or is Ms. Davidson the right?
I will go ahead and address it, Your Honor, because very specifically, the Wolf Creek objection to the proportionate responsibility question was very vague. It didn't even identify whose finding they were addressing. It stated simply plaintiffs object to question 3 as including a proportion of fault question without a predicate finding of any sort of negligent or other conduct. And as this court has
What
noted,
should it have said?
it should have specifically identified who needed to have been found at fault, but also how, with what language the jury needed to find that party at fault. And courts, including this court, have held on many occasions that a mere objection to a question, the objection that it's missing something, is not enough, that you must then propose the language. In fact, that's exactly what IROCK did when it proposed the language of the predicate instruction or question, whatever this court may consider it, but it wasn't even required to preserve that issue because it was a legal sufficiency issue on the large transaction exemption.
So your argument is that even if we don't look at whether there was a physical piece of paper that had the charge in substantially correct form, or the requested instruction, or I guess requested interrogatory, that the verbal language that counsel used during the hearing also did not set it in substantially correct form?
No, we contend that the verbal language is not an issue. We have no, and there was an agreement between the parties that we would read it into the record, but IROCK did that. Wolfcreek did not propose any question on predicate finding of fault to get to the proportionate responsibility question. And that's what we contend was the waiver. And your honors, I want to be sure to give Ms. Davidson plenty of time. Any further questions? This court should affirm. Thank you.
The problem going second, you always get burned a little bit on time.
Good morning. May it please the court.
Yeah.
The trial court correctly awarded Warren Katz reasonable and necessary attorney's fees under the RPO agreement. The applicable law in Texas is not limited to Chapter 38. Wolfcreek might have a point if the RPO agreement stated that lesser shall have all of the rights and remedies provided by Chapter 38 of the Texas Civil Practice and Remedies Code. However, the applicable law in Texas is that a party may recover its attorney's fees by statute or contract.
So what other independent sources, that if we're not looking at Chapter 38, where else are we looking?
Common law and the contract itself, case law, and the Romus Ventures case from the Texas Supreme Court.
That deals with, that's sufficiency, but with regard to this contract, did the contract itself say you're entitled to get attorney's fees?
The contract itself said lesser shall have all of the rights and remedies provided by applicable law, including recovery of attorney's fees and other cost of enforcing the RPO. And when the parties contract for attorney's fees, they can contract.
What does include the phrase including attorney's fees refer to? The right to recover or the applicable law?
I say it applies to all the rights and remedies provided by applicable law, which specifically includes the attorney's fees and the cost of enforcing the RPO.
So you're saying the applicable law will be the contract law?
Contract law, common law.
Okay.
So what other, I guess back to my earlier question. Let's say we disagree with you on the contract portion, that the contract necessarily needs to look to whatever applicable law means. And you said, I think you said that you thought the common law in and of itself also supported the recovery of attorney's fees, notwithstanding Chapter 38. What other portions of the common law have allowed that in the absence of a Chapter 38 of award of fees?
The common law has said that when parties contract for attorney's fees, if it is in a contractual, that the parties can contract to attorney's fees, if it is in an agreement. And when the parties contract for attorney's fees, the standard can be either stricter or looser than Chapter 38. Therefore, it does not matter that Wolfcreek is an LLC.
You're saying the common law is not just the American rule with regard to attorney's fees. You're saying
For case,
there's common
case
law.
law.
Yeah, common law includes case law too, and there's case law that says parties can contract for attorney's fees. That's what you're arguing?
Yes,
Okay.
from case law and the contract itself.
And I guess, I mean, I agree with you in that regard. I mean, one of the things that parties have thought about for years is definition of what a prevailing party means. For example, does it mean if you non-suit your case, on the day of trial and there's not a judgment that's taken, does that, I don't have any problem with that, but I'm trying to understand within the common law that you're arguing here. I guess really what you're saying is within the contract itself here, does the contract, I guess my thought is your argument seems to be circular. It seems to be saying you're entitled to get attorney's fees under, I guess, the common law, but the common law says you look to the contract. And so I'm trying to figure out what the source of the attorney's fees would be.
The source of the attorney's fees is in the contract, and Texas law states that the parties can contract for attorney's fees. And so therefore the fact that Chapter 38 used not to allow recovery against an LLC has no bearing on this case. Now, Warren Cat was a prevailing party on his breach of contract claim. However, one does not have to necessarily be a prevailing party.
No, and understand this is, here's where I'm coming from. I understand exactly what you're saying there. I guess my question is the phrase applicable law. Does applicable law modify the right to your attorney's fees? In other words, the contract easily could have said, in the event of litigation or in the event of whatever, you agree to pay our attorney's fees. I don't think there's any dispute with notwithstanding Chapter 38. The fact that you contracted for it means you get it.
Mhm.
What do we do with the applicable law portion? Does that modify your right to get attorney's fees?
It does not, because in Texas, in the state of Texas, the party can recover its attorney's fees by contract. The applicable law is Texas law.
Did you plead applicable law or did you plead in accordance with Chapter 38?
We pled, I know we pled for Chapter 38 originally. We also did a general plea for attorney's fees. And I think we did a plea for attorney's fees under the guarantee in the RPO. And then on our motion for attorney's fees, we pled under the RPO. And the parties in this case agreed that they would submit the issue of attorney's fees by affidavit submission. And the parties announced this on open court. And we cited in our briefs to that announcement. It's found in the reporter's record. Moving on
The
to
affidavits were supposed to come from who, both sides? Or just once the person requests?
the person who's requesting attorney's fees.
Was the other side given opportunity to file an affidavit contesting attorney's fees?
They did, and I believe that they did draft one. I don't know if it made it into the record.
How soon after attorney's fees requests an affidavit were filed in the court award fees?
How soon did the court
How soon did the court act?
I think it was approximately 5 days
5 days.
afterwards. Moving on to proportionate responsibility. Given the specific jury instructions in this case, and given the evidence presented in this case, the lack of a predicate question was at best not error, and at worst, it was not an error requiring reversal. Uncontroverted issues don't even have to be submitted to the jury. And in this case, there was legally and factually sufficient evidence that Wolfcreek contributed to its own damages. First, there was evidence at trial that Mr. Duke and Mr. Messer were overloading the crusher with rocks, and this prevented the crusher from operating at an optimal level.
Was anybody dispute that?
No, nobody disputed that the overloading caused the crusher to have
Anybody argue,
problems.
present evidence that we used the crusher in the manner it was supposed to be used, something to that vein?
Warren Cat claims it was not. There was some testimony that Duke was overloading it. At one point, he said, we had represented to him that he could put in 175 to, I think, 200 tons per, 150 to 175 tons per hour of concrete. And we said, you might be able to do a little bit more with caliche. There were times where he was putting in 400 tons per hour. And he did say at one time that we had told him that we could do double. However, and we dispute that, even if you doubled 100, if you multiplied 175 times 2, that would still be under 400 tons per hour. We never told him that he could do 400 tons.
Thank you, Council. Your time is up. Does the panel have any further questions? Thank you, Council. Mr. Jones, do you have final rebuttal?
Do you mind if I start with a question on the attorney fee question, the issue that Ms. Davidson brought up just a minute ago?
I do not mind at all.
She said that the parties announced on the record there was an agreement for presentation of attorney's fees. I'll tell you, I haven't personally looked at that portion of the case to determine what it said. Obviously, if the parties make an announcement on the record of that they're going to do something, that might constitute a Rule 11 agreement, which would be a separate contract if enforced that way. What did the parties say there, if you know?
The parties agreed that we weren't going to put on our attorney's fees testimony live, that we would submit affidavits for the attorney's fees.
What were there statements in there? The parties agree to be bound by attorney's fees, or the prevailing party gets fees, or anything like that?
I don't believe there was anything to that effect. It was that we would submit the fees by affidavit rather than putting on live testimony. I want to start by addressing a point in the proportionate responsibility portion of the argument. There's some statement that Wolfcreek didn't object to being excluded from the predicate liability findings. 2 points there. One, the predicate liability findings with regard to question 3 dealt with the DTPA. And so when question 3 was asked, it was referring to those DTPA questions and said that you may find Wolfcreek was responsible for its own injury. That violates Rule 277, which requires in the apportionment of fees that you apportion fault among those who have been found to be liable or found to be culpable. And so there has to be a predicate finding of culpability at some level of, legally cognizable bad conduct for the proportionate fault or proportionate responsibility question to come into effect in the first instance.
I think Ms. Geary was making the argument that even if that's the case, you didn't have a submission in substantially correct form that actually asked the jury, that actually asked the judge to include that in the charge.
Our objection was directly to, well, we weren't going to object to being left out of question 2 about DTPA violations. Wolfcreek didn't violate the DTPA. We weren't going to argue that we violated the DTPA, and we were under no obligation to put forward defensive questions for the defendants, being the liability of Wolfcreek for any injury that it had. Those are defensive questions that we didn't own, so we're under no obligation to attempt to get them in the charge.
Well, what about the question dealing with proportional responsibility?
We did object to that, and we objected to be included without a question regarding what level of fault or like negligence. Did we violate a DTPA standard upon ourselves? Is it more like an Animal House defense?
Was there
by trusting them?
Was there a written submission though, or was it merely an objection?
We agreed to forego the written submission. It was on the record agreement, and in the 6th reporter's record around like page 7, we talked about agreeing that we're going to do the substantially correct wording verbally, and that's why I don't think any of us actually met the legal standard for substantially correct wording.
Did you properly substantially correct verbiage wording verbally? I think that's what Ms. Gary's saying, is you didn't do that. You just said we want
Oh,
a predicate question
we're objecting to being included within the question without there having ever been a predicate question about our culpability.
Right.
They didn't submit their own defensive issue about our proportionate responsibility. They didn't.
Who had the burden? Did you have a burden to submit a substantially correct issue, or was it their issue? They had the burden to do it, or does it matter?
Appellants did not have the burden to submit a substantially correct defensive issue that belonged to the defendants, the case, the appellees. It would be akin to if contributory negligence hadn't been subsumed by Chapter 33, saying that we had to object to not being included in a contributory negligence question as planned.
So in your view, it was enough just to object?
To object to the inclusion of Wolfcreek in the proportionate responsibility question when there was no other question fixing Wolfcreek's culpable conduct as required by Rule 277 in apportioning fault. A couple of other things I wanted to touch on. Justice Doss brought up the prevailing party language. There's a whole body of case law regarding prevailing party in contract fee award cases. One of the problems here is that the contract itself has no standard for when fees would be awarded, unlike, for instance, the Rumors case that was cited earlier, which provided that in any action to enforce the terms of this lease, the prevailing party shall be entitled to an award of attorney's fees. Or in the KC Pharmacies case that they also cited, which had substantially similar language regarding prevailing party status and specifically saying would be awarded attorney's fees. Here, there's none of that language, and the award of a fee seems to be tied to the antecedent applicable law, because it's
If they omitted the phrase applicable law, would you say they were entitled to attorney's fees? Rights and remedies, including attorney's fees.
probably, yeah.
So applicable laws, what conditioned rights and remedies?
Right, and my assumption is that that language was put in there to cover multiple
The
states.
concept that you can contract for the payment of attorney's fees.
No, I do not disagree with that concept at all.
So with that, and is that based on applicable law? There's law that says you can contract for the payment of fees?
There certainly is law that says you can contract for the payment
Why
of
wouldn't
fees.
that law be applicable law for purposes of this situation in your view?
Well, one, because if that were just by itself sufficient, then it would read out the word including and just be and within the contract. So giving effect to all the words, we have to look to what the word including means and what it modifies. And so it specifically refers the attorney's fees to the applicable law as the basis for recovery. Moreover, just interpreting it as you get attorney's fees if there's an event of default means what? Who's the prevailing party? Do you even have to file a lawsuit? It's a huge mess. If there's no standard, no other language to guide the contracting parties to when fees would be awarded. Unless you look to applicable law, which says, 38.001 is how you would enforce in the contract attorney's fee.
My question took you over your time limit. Let me ask the other judges have any questions? We appreciate you coming. The case is submitted and you are excused to go. And we will be in a brief recess so we can change panels. So thank you guys and safe travels home.